Welcome back to This Week in Immigration. I'm Jordan LaPier. On this week's program, what the Supreme Court's DACA ruling means for the program's future, how the Trump administration is stepping up its efforts to limit legal immigration during the pandemic, and whether new regulations have effectively shut down America's asylum system. All that's just ahead. Stick around. Here with me today, as always, are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hey, Theresa.
Hi, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst, on Twitter at CRamonBPC. Hi, Cris.
Hey, Jordan.
Last week, the Supreme Court finally issued its long-awaited decision on the administration's efforts to unwind the DACA program, and it was something of a surprise. Chief Justice John Roberts joined the majority in a 5-4 decision finding the Trump administration ended DACA unlawfully. That decision allows hundreds of thousands of DACA recipients to breathe a sigh of relief for now. But is this a true victory from the court or just a temporary reprieve? So, Theresa, what were the legal issues involved in this case, and what did the majority say in its ruling?
So the primary legal issues involved in this case was not whether or not the Trump administration had the authority to terminate the DACA program, but whether or not they did so properly. So it primarily was a case grounded in the Administrative Procedure Act, which is the law that governs executive actions. And the most important part of that law is that an executive agency, an administration, cannot act even if it's within its statutory authority, in a quote-unquote arbitrary and capricious manner. And what the court said was that the way the administration wound down the program was arbitrary and capricious. And they held that on two grounds. First, that they relied on an opinion from then Attorney General Jeff Sessions that the DACA program created by the Obama administration was illegal, in part because of a Fifth Circuit decision in a subsequent case about DAPA, the expanded provision that Obama tried to get in place, that providing benefits to people protected from removal was a burden. So the court said that the administration in terminating DACA did not consider whether or not there was something else they could do, maybe limit benefits and still protect people from deportation, that would have met that legal obligation. So they said they basically didn't do enough legal reasoning of alternatives. The second thing the court said that they did not do that they should have was understand how many people have come to rely on this program, so-called reliance interests. And that's not just the recipients of DACA themselves, but their employers, their family members, which oftentimes may include U.S. citizens who are dependent on them and their work authority. So that basically a summary conclusory statement that the program was illegal was just not enough of a reasoning. And that was the basis of the majority's opinion.
Cris, what does this truly mean for the future of the program, though? The president has been tweeting his desire to try again to terminate DACA before the election this fall. Does this ruling prevent him from doing so at all?
It's interesting because if you saw how immigration advocates were reacting to the news, when the first news broke, everybody was very excited. And by the end of the day, I think there was a lot more reservation because there was a recognition that the administration can, in fact, terminate the program. And even more importantly, there's a footnote in the decision saying that they don't even have to give notice and comment if they're issuing a regulation, for instance, for eliminating the program. So the administration can move forward with terminating the program. The key question is just a question of timing. They can issue that order right away, and try to sort of, eliminate the program. But there's always the question of litigation and timing, because it's really a question of, do they issue it and then does it get enjoined in litigation? Does that then keep things from moving along, from trying to terminate the program and terminate the program before the November election, where, if President Trump loses, obviously, we'll see what happens with that litigation. But the administration can act quickly. But the question, again, is can it act quickly and actually produce results? Produce results in the way of just actually being able to terminate the program. So I think that's the key thing, is that the administration has the time, has the ability, but can it actually end the program within the end of the year, that's the open question.
Theresa, this all seems a bit like deja vu. I mean, here we are again with the president trying to prod Congress into making a deal with him on DACA. Last time, the president told Congress he wanted to find a solution, but Congress and the White House failed to reach consensus despite some close votes in the Senate on several different compromise approaches. Is there a sense that this time around is going to be any different?
Well, that's an ongoing question. I mean, I think, obviously they have to take at least some time to come up with a better rationale, even if they issue a new memo. It has to have a better rationale if they hope to avoid another court injunction, as Cris said. But the other question outstanding is whether they would terminate the program immediately or allow, quote unquote, an orderly wind down as they did the last time. They actually said that the program would terminate 6 months after the order, so that purposefully to give Congress time to legislate a solution. So that's another outstanding question. Even if the administration issues a new memo, would they still have that 6-month wind down, which would take us till after the election, or are they looking to wind it down sooner? And then what does Congress do? To be honest, the fact that the Supreme Court allowed the program to continue as it is right now takes some of the pressure off of Congress. And, we knew that was the case after the lower courts had issued an injunction against terminating the program. Congress sort of tried and failed and then said, oh, well, the program's still going. We don't have to do anything for a while. Most people thought the Supreme Court would rule for the Trump administration, and people were gearing up, including in Congress, to figure out, well, how are we going to respond? Are we going to try to legislate right away? There's a little bit of a pause now to see kind of what happens. But there's still a lot of support in Congress for providing a permanent status for DACA recipients and broader dreamers. It's very popular in the public. There's been several polls released in the last week showing broad bipartisan public support for providing legal status for dreamers. So there's got to be sort of a political question, an electoral question about whether or not terminating the program right now is good for the Trump administration. And for members of Congress, they're trying to figure out, I think, whether voting on something right now is helpful or hurtful to their reelection campaign. So there's a whole lot of politics involved here. For Democrats, if they think that there's a good chance that they will have a Democratic president in January, do they even want to come to the table to deal with this president? Or do they wait and see if a new president would continue the program? And whether or not they take back the Senate, for example, and retain the House. For Republicans, it's all eyes on the president. What's the president doing? What's the president asking? I think a lot of Republicans would just assume the president do nothing. Don't try to terminate the program. Let this go to November and then see what happens and figure out a lame duck. So I think that we have to kind of wait and see whether Congress will try to take on legislation before the election. I think it would be wonderful if they did, but I also think it's maybe unlikely at this point in time.
Okay, when we come back, new steps to limit immigrant visas. Last month, President Trump issued an executive order suspending the issuance of most immigrant visas for people coming from abroad for green cards, saying he aimed to protect jobs for Americans. There were also rumors then that the administration would look to restrict temporary work visas, and on June 23rd, the administration did take those steps, with the president issuing a new proclamation extending the immigrant visa suspension through the end of the year and expanding it to cover most types of non-immigrant work visas. Theresa, what's covered in this new proclamation and who does it affect and for how long?
Sure. So the first thing to say is that it extends that original proclamation through the end of the calendar year. So all of those immigrant visa categories of people who were prevented from getting an immigrant visa overseas and coming to the United States, the employment-based categories, except for EB-5 and certain exemptions, and some family-based categories, as well as diversity lottery categories, are prevented from coming in. It expands that to cover several non-immigrant visa categories, specifically H-1B for skilled workers, H-2B for temporary non-agricultural workers, J visas, which are exchange visitor visas in particular categories, those coming for internships as a trainee, a teacher, a camp counselor, an au pair, or the summer work travel program. anyone coming on an L visa, and L visas are for intra-company transferees. So a multinational company that has affiliates, subsidiaries, parents overseas can transfer managers and executives from abroad to the United States under the L category, as well as individuals who have specialized knowledge of their product or service into the United States. Those are all suspended as well. So it has a pretty broad impact. These are some of the most heavily used, particularly H-1B, H-2B, and L are the most heavily used work-based visa categories, non-immigrant visa categories for people coming into the United States. In addition, there are some exceptions. There are exceptions for anyone who is coming to provide temporary labor or services essential to the U.S. food supply chain. So certain H-2B workers in food processing, for example, might be exempted under that category. And anyone who's deemed to be, quote unquote, in the national interest as determined by the State Department and DHS. So there are some additional guidance and rulemaking that has to come from the agencies as to who else might be accepted. There's some indications that exceptions should be made for people in the healthcare professions or people who are coming to deal with research related to COVID-19. But again, we have to kind of wait and see how those categories are implemented.
Cris, in addition to the visa suspensions, the proclamation orders DHS and other agencies to restructure the H-1B visa program and restrict issuance of employment authorization in the United States. What do you make of those provisions?
It's interesting because I think the thing that really struck me is that the administration wants to issue H-1B visas based on the salaries that employers are willing to pay for their employees. And this is significant because this isn't necessarily totally written into statute. It's an interesting way of trying to reform the program through regulation. Currently, right now, the H-1B operates sort of as a lottery. Employers file their petitions for an H-1B for a potential employee, and then there's a lottery, and if they're able to get an H-1B visa for their employee, they're able to do so, and if they're not, they're not. So there's certainly a little bit of randomness that's involved in there. But certainly that system does allow, or at least doesn't, impact negatively companies that may not be able to pay enough for their employees. So particularly, for instance, like nonprofit organizations. But the current system, there are some benefits, obviously, that there's more regularity in how and who and which companies will get H-1Bs. But I think the thing is, once again, this might be a little bit more unfair for employers that can't pay their employees enough. So this is really interesting. This is something that various organizations have proposed. But again, the point is that the regulation, or at least this executive order that's doing this, certainly is doing it without any type of congressional input, and I think that's sort of a little bit problematic. It's not unlike the way that we saw with the public charge rule that assessed whether or not an individual could get a green card based on potential or past uses of public benefits, incorporated sort of a merit-based assessment of an individual based on a series of categories as to whether or not they can get that green card. So it incorporated that without congressional approval. So I think that is the thing that stuck out to me the most about the executive order on this, that it's kind of, once again, showing the administration trying to tweak the immigration system through executive action without any congressional input or approval, and trying to sort of shift it in a way that tries to restrict immigration.
Yeah, the only thing I would add to that is that there are provisions in here that require the Department of Labor to promulgate new regulations or consider promulgating regulations that would tweak the labor market tests that are in law for employment-based immigrants or H-1Bs or H-2Bs, and that may end up making them harder to achieve. And then there's this broad category that doesn't talk about promulgating regulations, but actually preventing aliens who have, quote, final orders of removal, who are inadmissible or deportable from the U.S. or have been arrested for, charged with, or convicted of a criminal offense in the United States from obtaining eligibility to work. this could broadly apply to lots of categories of people who currently get employment authorization documents, including asylum seekers, which we know that there was a proposed rule put out on that, which we'll talk about, TPS holders, and frankly, DACA recipients who would be inadmissible or deportable, but for the protections offered under those programs. So this could be a very broad sweeping reduction in the number of employment authorization documents that are granted each year.
Cris, on that note, many businesses have decried this move as hurting the economy rather than protecting jobs for Americans. What do you make of the rationale for these orders, and what do you think it says about the current immigration system more broadly?
So I think what's interesting is that if you look at the data on H-1Bs, what occupations that involves, you're seeing individuals who are software developers, computer system analysts, working in computer occupations. They're largely working in high to slightly mid-skilled industries, but primarily high ones. And this is interesting because what you're seeing is that right now, with the current recession, is that service sector economies are the ones that have been impacted the most. So it's interesting when you see this, this mismatch between trying to prevent these individuals from coming into the United States, but at the same time, they're not coming into industries that have been suffering the most over the last couple of months. So this actually raises a lot of questions as to what the true intent of the of this new order is, because the question is, well, if you're not actually protecting jobs in industries that have suffered the most, what's the purpose of this? And I think this is where it sort of indicates more, I think more clearly than not, that the administration wants to continue to pursue its long-term goal of trying to limit the legal immigration system. And this has been a long-term goal. In February 2018, I wrote, an info brief that examined how the administration was looking into regulations to target high-skilled workers, particularly on H-1B visas. And then these are regulations that they started considering in 2017. So this really shouldn't be a surprise that the administration is taking this step, but I think it is trying to at least try to find ways to limit immigration under the pretext of trying to protect jobs. So I think that's really the key thing, is is this actually necessary? Would this actually protect American jobs? And it doesn't seem like that's actually the case. And so, like I said, what is the administration trying to do with this? And is it using this current recession to take advantage of this opportunity to do what it's been wanting to do for a long time?
All right, after the break, what's happening with the asylum system? In the last several months, the Trump administration has also issued several new policies and regulations limiting access to asylum, and this week it published a new final rule limiting employment authorization for asylum applicants. Advocates have claimed that the administration is essentially shutting down the country's asylum system. To discuss the history of the asylum system and the impact of these actions, we welcome back to the podcast Ruth Wasem, professor of public policy practice at the LBJ School at the University of Texas in Austin, and a BPC Fellow. Hi, Ruth.
Hello, it's good to be back.
Ruth, tell us a little bit about how the modern asylum system in the United States has developed and evolved over recent decades.
Well, the modern era of U.S. asylum policy began with the Refugee Act of 1980. And that act defines a refugee or asylee as someone who is unable or unwilling to return home because of persecution or a well-founded fear of persecution on account of one of 5 traits: race, religion, nationality, membership in a particular social group, or political opinion. While the Refugee Act of 1980 was responding largely to people displaced abroad, particularly in Southeast Asia at that time, its first big test was actually mass migration of asylum seekers, known as the Mariel Boat Lift, which brought 125,000 Cubans and 25,000 Haitians to South Florida over a 6-month period. The 1980 Act did include provisions for foreign nationals arriving in the United States or who were already in the United States to seek asylum, but it's fair to say the asylum system was not prepared in 1980 to respond to large groups of people. Over the past 40 years, The asylum system has matured in response to civil wars in Central America, coups in Haiti, political oppression in Cuba, and most recently, the widespread violence in Central America. Along the way, major court cases prompted reforms in the early 1990s to detach asylum decisions from foreign policy pressures and to elevate and create an asylum corps of professionals in what is now U.S. Citizenship and Immigration Services who would hear asylum claims. So at that point, asylum seekers had two bites at the apple: an asylum review before USCIS officer, and if that did not result in approval, the opportunity to request asylum before an immigration judge during removal proceedings. And all people who were apprehended and going into removal proceedings could also request asylum. You didn't have to have been in the asylum system before that. Well, in 1996, as many of you know, there was a sweeping overhaul of U.S. immigration enforcement law, the Illegal Immigrant Reform and Immigrant Responsibility Act. And among the provisions in that act were significant changes to asylum. They included expedited removal of foreign nationals arriving without proper documentation, and the mandatory detention of foreign nationals arriving without proper documents, who express a fear to an immigration officer, a fear of being returned home. So that's a key part that triggered the asylum protections. The 1996 law also barred foreign nationals who can be returned to what is known as a safe third country from seeking asylum in the United States. It's fair to say that the Clinton, Bush, and Obama administrations were very prudent in implementing these changes in both the affirmative asylum system within USCIS as well as in the defensive asylum system that is in the Department of Justice Executive Office on Immigration Review, those immigration courts. And through the years then, there have been a series of rulings that have clarified that certain gender-based crimes, persecution based upon LGBTQ, and victims of gang violence could qualify for asylum if the home country where they were fleeing from was unable or unwilling to afford protections to those fleeing. So this was kind of where we stood, an affirmative and defensive system with that based on both restrictions from 96 as well as more generous rulings and interpretations by the courts as we got into the Trump era.
And Ruth, how do these new moves by the Trump administration shift the direction of the system?
Well, I think it's safe to say that throughout the Trump years, we have seen dramatic shifts in asylum, particularly at ports of entry, and people that are seeking asylum upon arrival. And and I know that the Bipartisan Policy Center has written about this extensively and has some wonderful reports that talk about how these changes have played out at the ports. But what is many of these changes were policy shifts and pushing the limits of the 1996 Act, really pushing that as far as they could in terms of expedited removal and safe third countries. What we're seeing in the rule, proposed rule, it's a proposed rule, and there's a 30-day comment period. If any of our listeners want to read the proposed rule and comment, I encourage them to do that. It's not an easy read. It's 169 pages. But there's a couple key things that they do. They make it a lot harder for someone seeking asylum to actually get a hearing before the judge. They would these rules would allow a judge to just read the application for asylum form and dismiss the asylum claim without a hearing, and that's a dramatic departure from current law, and it has narrowed the definition of a refugee or asylee, rolling back the court cases of gender-based claims, LGBTQ, gang violence. So we're back to a much more narrow view of who's eligible for asylum, and there's a lot more consequences of when they've traveled through a third country about whether or not that is really a safe third country. So it's fair to say that many of the critics of the Trump administration feel that this proposed rule would shut down asylum. And I think that if it was enforced as it's proposed, very, very few people would be able to qualify for asylum, or even, frankly, get the opportunity to have an asylum hearing before a judge. So there are a lot of concerns about the reg, and I don't want to take any more time at this point, but it's a pretty sweeping overhaul that takes the 1996 Act, pushes it to extremes, and I would expect that there will be court cases if these rules are promulgated. If the proposed rule is promulgated, there will be court cases challenging it.
Theresa and Cris, you've both previously spoken about the efforts of the administration to use other countries as barriers to asylum seekers coming to the United States. What do you make of these new moves to change U.S. policy and regulation here?
So the way we should look at this is basically is the administration's insurance policy against whether or not the policies that it's enacted up until this point, if those policies go away. And when I say this specifically, it is essentially sort of trying to gut the asylum system and make it difficult for individuals to get it when they arrive at the U.S.-Mexico border. And the reason you should consider that as insurance policy is because you're looking at the migrant protection protocols, the asylum cooperative agreement with Guatemala. You've got PACER and HARP, and you've got the Title 42 order that's been recently implemented that allows CBP to basically expel individuals from the U.S.-Mexico border literally within 30 minutes. You've got all these policies that largely rely on cooperation with other countries, primarily Mexico and Guatemala. So if at any given point these policies go away, either because Guatemala and Mexico refuse to cooperate for some reason, or that there is successful litigation, this new regulation will still be in place to limit the capacity of individuals to access asylum at the U.S.-Mexico border. So I think that's the key takeaway point, that the administration is trying to sort of limit the asylum system, sort of future-proofing against any effort to limit what's already trying to do at the U.S.-Mexico border of limiting asylum for individuals who are arriving there.
Yeah, I would also just say that in addition to hedging their bets against what other countries may do in cooperating with asylum removals, they're hedging their bets against losing the election. So many administrations will try to push forward final rulemakings in the waning days of their administration, the so-called midnight rules, because it is a lot harder for a subsequent presidency to repeal a final regulation than it is, for example, an executive order or a policy that is made without that. Regulations are a much more formalized process. So it's a proposed rule right now, as Ruth said, but they could finalize it before leaving office should they lose the election in November. In January, and then it would take a lot longer for a subsequent administration to unravel that regulation, which would put it in place for quite a while. So I think that there's both hedging the bets against what other countries may do, but also hedging bets in case the administration loses the election.
Lastly, what do you all think will be the future of asylum in the United States? Theresa, I'll start with you on this one.
As Ruth outlined, the asylum system in the United States has undergone a lot of change over the last several decades since it was implemented in 1980, and very quick changes in the last 3 years of the Trump administration, for sure. But I think one of the things we're going to have to grapple with is that the asylum system, the refugee protections, were set up with the idea that persecution was the main factor, and persecution was something that was conducted by, if you will, a state. a state authority, you were being persecuted by your government, or your government was choosing purposefully not to protect you from persecution. And so much of the interpretations of that have resulted are trying to address problems that were not really what the original definitions of persecution considered. These things like gang violence or systemic social issues such as women who are battered in their marriages, or the LGBTQ community. So I think that honestly, we probably are due for a revisit of the statutory basis for this. Certainly the changes that were made by the 96 Illegal Immigration Reform and Immigration Reform Act, IRA, that limited the ability of courts to look at some of these cases, the expedited removal things. I think all of these are due probably for a legislative revisit. Do we need to rethink what we mean when we talk about asylum and refugee protections to address some of these new modern issues?
Another point, and I agree with Teresa's observations. Another point was that asylum, when you're just talking about an individualized case, and I will say, people from the People's Republic of China, people from Venezuela, they're getting asylum in the United States. If you look at the data on who's getting asylum, people are still getting asylum. What is at issue is how do we respond to mass influxes of asylum seekers? And that's where we need to be much more thoughtful. And the 96 provisions originally grew out of provisions that came from the Florida delegation largely, that were designed to only occur in emergency situations and not be applied across the board all the time. But it became policy when they enacted it that would be in place all the time in the context of expedited removal. So in addition to thinking about what is a refugee or asylee, the definitional issues, also from an administrative and a policy trigger, what do we have as dealing with these mass influxes as opposed to ordinary time, if there is ordinary time?
And I agree with that. I think, and it's not just the United States. Europe encountered this as well with the European refugee crisis or the migration crisis, whatever you want to call it. Fundamentally, our asylum system has largely assumed that there is a stark line between an asylee, which has largely been considered during the Cold War, a political asylee, an individual who comes to a country to seek protection, and a refugee, individuals who are camped out in refugee camps and that are being processed overseas. What we've been seeing, and actually we've been seeing since the 1980s, is that there's sort of a fusion between the two. Large movements of asylum seekers, so large numbers of individuals that you would assume would be refugees, but moving to countries or regions seeking protection. And I think that that's fundamentally, not only in the United States, and not only in Europe, but globally is going to be fundamentally the problem of how you manage these large influxes. So it's not only that we need to reconsider how we manage migration and asylum seekers here in the United States. I think globally, this needs to be a very important conversation. Because, for instance, if you're considering climate change, and there might be climate refugees, whatever term you want to use for those individuals are going to be moving en masse down the line. It may not be in the next decade, but it might be further down. And I think that there's going to be an enormous reckoning if we can't rethink the global humanitarian protection system in the future in the next couple of years.
All right, Cris, Theresa, Ruth, I think that's a good place to leave it. Thanks so much. And thanks to you for listening. We'll be back in 2 weeks. Before we go, a quick reminder to subscribe, rate, and review this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or your favorite podcast platform. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. This Week in Immigration was created by Theresa Cardinal Brown and myself. The executive producer of This Week in Immigration is Theresa Cardinal Brown. This week's episode was written by Theresa Cardinal Brown, Cris, Ramón, and myself. Our producers are Cris, Ramón, and Yafat Tawahara, and our editor is Yafat Tawahara. The executive producer of BPC Podcasts is Ashley Swearingen. I'm Jordan LaPier. Join us again next time on This Week in Immigration.